In 1884, the Supreme Court ruled that a Native American man born on United States soil was not an American citizen. He could not vote. He had no constitutional protections. Now, 140 years later, the Trump administration is resurrecting that very ruling to fundamentally rewrite who qualifies as a citizen at birth. Legal scholars across the political spectrum are sounding the alarm. Here's why. Welcome to Court Decoded. Today, we examine how a forgotten 19th century case denying citizenship to a Native American man has become the centerpiece of the most significant challenge to birthright citizenship in American history. John Elk was born on a Native American reservation in the United States. The exact year and location remain debated by historians, but what is certain is that he made a choice that would echo through the centuries. Elk voluntarily left his tribe and fully assimilated into American society. He worked, paid taxes, and lived as any other resident of Omaha, Nebraska. By every measure of daily life, John Elk was American. In 1880, he walked into a voter registration office to exercise what he believed was his fundamental right as someone born on American soil. He was turned away. The registrar, a man named Charles Wilkins, refused to register Elk to vote. The reason given was simple and devastating. Despite being born within United States borders, John Elk was not considered a citizen. He had no constitutional rights. This rejection would set the stage for a Supreme Court battle that still resonates today. To understand why Elk believed he had a case, we must examine the 14th Amendment. Ratified in 1868, just 16 years before Elk's legal battle, this constitutional amendment contained what appeared to be an unambiguous promise. The Citizenship Clause reads, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States." These 28 words were designed to overturn the infamous Dred Scott decision, which had ruled that Black Americans could never be citizens. The amendment's framers intended to create an ironclad guarantee. If you were born on American soil, you were American. No exceptions based on race, parentage, or social status. John Elk believed these words protected him. He was born in the United States. He had fully embraced American society. Surely, he thought, the Constitution was on his side. In 1884, the Supreme Court delivered its verdict in Elk versus Wilkins. The decision was a crushing defeat for John Elk and a narrow reading of the 14th Amendment that would have lasting consequences. The court ruled that the phrase "subject to the jurisdiction thereof" did not simply mean following American laws. Instead, the justices interpreted it to require complete political allegiance at the moment of birth. Because Elk was born on a reservation, the court reasoned he was born under the jurisdiction of his tribe, not the United States. His later decision to leave his tribe and assimilate was irrelevant. The court declared that an individual could not, by their own actions, make themselves a citizen. Citizenship required a birth under full United States jurisdiction or an act of Congress. John Elk had neither. The message was clear. Being born on American soil was not enough. The government could determine who was truly subject to its jurisdiction. For over a century, Elk versus Wilkins gathered dust in legal archives, largely superseded by subsequent legislation and court decisions. Then, in 2025, the case returned to the national spotlight. President Donald Trump signed an executive order attempting to end birthright citizenship for children born to undocumented immigrants on American soil. The legal justification cited by the administration reached back 140 years to John Elk's defeat. The administration's argument follows a familiar line of reasoning. Just as the 1884 court ruled that Native Americans on reservations were not fully subject to United States jurisdiction, the Trump administration now argues that undocumented immigrants exist outside full American jurisdiction. Therefore, their children, even if born in American hospitals on American soil, should not automatically receive citizenship. It is a direct challenge to how birthright citizenship has been understood for generations. The response from constitutional scholars has been swift and largely critical. Legal experts across the ideological spectrum have raised serious concerns about using Elk versus Wilkins as precedent for modern immigration policy. The core objection centers on a fundamental difference between the two situations. Native American tribes in 1884 existed as semi-sovereign nations with their own governance structures and treaties with the United States. The Supreme Court treated tribal members as belonging to separate political entities. Undocumented immigrants, critics argue, exist in an entirely different legal category. They are not members of sovereign nations within American borders. They are subject to American law in every meaningful sense. They can be arrested, tried, and imprisoned under the American legal system. If that is not being subject to the jurisdiction thereof, scholars ask, what is? Furthermore, the 14th Amendment was specifically designed to prevent the government from picking and choosing who qualified for citizenship based on ancestry or status at birth. Those challenging the administration point to another Supreme Court case that directly addressed birthright citizenship. In 1898, 14 years after Elk versus Wilkins, the court decided United States versus Wong Kim Ark. Wong Kim Ark was born in San Francisco to Chinese immigrant parents who were legally prohibited from ever becoming citizens themselves under the Chinese Exclusion Act. When Wong returned from a trip to China, he was denied re-entry to the country of his birth. The Supreme Court ruled decisively in his favor. The court held that anyone born on American soil, regardless of their parents' citizenship status or race, was a natural-born citizen under the 14th Amendment. This decision has been the controlling precedent on birthright citizenship for over 125 years. Supporters of the executive order argue that Wong Kim Ark's parents were legal residents, distinguishing it from children of undocumented immigrants. Critics counter that the court's language was far broader, encompassing all births on American soil. The implications of this legal battle extend far beyond abstract constitutional theory. If the Trump administration's interpretation prevails, the immediate impact would be staggering. Estimates suggest that approximately 300,000 children are born each year in the United States to undocumented immigrant parents. Under the executive order, these children would not be American citizens. They would have no right to American passports. Their access to public education, healthcare, and social services would be fundamentally altered. But the ripple effects extend further. Children born to parents on temporary visas, including work visas, student visas, and tourist visas, could also have their citizenship status questioned. Legal scholars warn that the precedent could eventually be used to challenge the citizenship of children born to legal permanent residents who have not yet naturalized. The definition of subject to the jurisdiction could be interpreted ever more narrowly, potentially affecting millions of families who have long considered themselves unquestionably American. The executive order immediately faced legal challenges in federal courts across the country. Multiple judges issued preliminary injunctions, temporarily blocking the order from taking effect. In their rulings, these judges expressed skepticism about the administration's constitutional arguments. One federal judge noted that the order appeared to contradict over a century of settled legal understanding about the 14th Amendment. Another pointed out the irony of using a case about Native American rights, a population that has historically faced systematic legal discrimination, to deny rights to another vulnerable group. The administration has appealed these rulings, setting the stage for the case to potentially reach the Supreme Court. There, the conservative majority will face a profound question: whether to embrace an expansive reinterpretation of the jurisdiction clause that could fundamentally alter American citizenship, or to uphold the broader reading that has defined birthright citizenship for generations. The legal community watches with bated breath. The ultimate fate of birthright citizenship now rests with the courts. What began as one man's fight to vote in 1884 Nebraska has become the foundation for the most significant challenge to citizenship rights in modern American history. John Elk lost his case and never saw justice in his lifetime. Native Americans were not granted full citizenship until Congress passed the Indian Citizenship Act in 1924, 4 decades after the Supreme Court told Elk he was not American enough. The legal lesson here is profound. Constitutional interpretation is never truly settled. Cases that seem relegated to history can be resurrected to reshape the present. The words of the 14th Amendment have not changed since 1868, but their meaning remains fiercely contested 157 years later. If this case fascinated you, hit subscribe and the notification bell to never miss a Court Decoded episode. Share your thoughts in the comments below. What should the Supreme Court decide?